right, here we are back at chapter 3 of EMT, and in this chapter we're going to talk about medical, legal, and ethical issues as they relate to the job of an EMT. This chapter is actually, it's a little long, at least the presentation is, so it's probably going to push close to an hour and 15 minutes, maybe an hour and a half, so feel free at about the halfway point, maybe about 45 minutes in, to hit the pause button and take a break, or hit stop and come back later. You're not going to hurt my feelings if you just walk away for a little bit, kind of rest your brain, maybe get some a bit of a mental break away from listening to the droning sound of my voice, along with the occasional sneeze. I recall now that for the first 2 chapters, at some point in time, about the middle of the lecture, I sneeze. So I'm not promising I'll do that this time, but if I do, it's just me trying to hold on to tradition. All right, so let's get started with chapter 3. So basically, the core principle in emergency care is to avoid causing additional harm. So we want to help people, but we don't want to hurt them more along the way of trying to help them. So healthcare providers in general are pretty well protected legally, as so long as they're acting in good faith and they're working within the acceptable standards or the accepted standards of their profession. So as long as you're working within the job that you're supposed to be doing and you're following guidelines, protocols, those kinds of things, you're not going out there with a kit of things in the back of your car, trying to be, Johnny on the spot or Ricky Rescue, those kinds of things, you're going to be okay. If you start doing those freelancing kind of things, that's where you can get a bit of trouble. So, but even though you may do everything right, you may do everything well, patients sometimes are not happy and they're going to file lawsuits looking for some sort of financial compensation or something like that. So in the next chapter, when we talk about how we document things, we'll talk about ways that we can, try to mitigate or reduce the chances of actually being sued, either our company or us personally. So the first thing that we're going to talk about, though, and it's kind of a big one, and this one is always a bit confusing for new EMTs. So when it comes to consent, we need to make some things very clear. What consent means giving permission to receive medical care. And just because somebody consents to you taking them or taking care of them doesn't mean that they automatically consent to every procedure or thing that you're going to do to them along the way. Each step of the way, you need to make sure that the patient is okay with what it is you're doing. You ask them, is it okay if I take your blood pressure? Is it okay if I listen to your lungs? Or do you want us to take you to the hospital? Those kinds of things. We're going to get consent along the way of everything that we do. It seems a little silly to do things that way, but we need to make sure that the patient is consenting to what we want to do. And a patient must agree before we can give any treatment or anything or provide them with any kind of assistance. If a patient is alert, rational, and able to make informed decisions, they have the legal right to even refuse care. So if they're basically in their right mind, they're rational thinking, and they're alert, they can say they don't want you to do anything for them. Sometimes this is a tough pill to swallow when you know that they clearly need somebody to intervene and help them, but it is their choice. They have the right to decide what happens as far as their own medical care and their treatment goes. So consent is really based upon the patient's ability to make informed decisions. They need to have a good decision-making capacity. A patient must be able to understand and process the information that you provide. The patient must also be able to make a clear, informed choice about their care, about what they want to do. Most patients are very clear in that. Just the simple fact that they called for an ambulance is a bit of an indication that they want your help, but we still need to make sure that it's very clear. Then there's this thing called patient autonomy. So patient autonomy has to do with the patient having the right to make their own decisions regarding their own health care. So patients have autonomy. They can make choices about their own health care as long as they're an adult. a legal aged adult, and there are some other instances where they don't have to be legal aged, but we'll talk more on that a little bit later. So we need to make sure that if someone is trying to refuse care or refuse us to do a particular procedure, we need to assess whether or not they have good decision-making capacity. So we need to consider whether the patient is affected by mental limitations such as dementia, or some other organic brain syndrome or something along those lines, or some other disability. We need to make sure the patient is of legal age, usually 18 or older in most states. There are some exceptions to that, as I mentioned, but we'll get into those later. Check for any impairment from alcohol, drugs, serious injury, or even illness that may be hampering their ability to make good decisions. Determine or decision-making, adequate decision-making. I don't even know if that's really good. That they have a good decision-making capacity. They may not always make a good decision. Clearly, if they're under the influence of drugs or alcohol, maybe they haven't been making good decisions. But so it doesn't have to be that they're able to make good decisions. It's just that they have decision-making capacity. They're capable of making informed decisions. Determine if the patient is in significant pain that might affect their thinking, and be aware of any major injuries that might distract the patient from their other problems. Look for hearing or vision issues that could interfere with their communications, and identify any language barriers that might be preventing them from understanding exactly what it is that you're asking or what you're wanting to do. So don't hesitate to clarify. Sometimes we use medical jargon and words and things like that patients don't understand, and they might say no just because they don't understand, or they think they know what you're going to do, so be aware of that those things can kind of sometimes get a little misconstrued. Observe when the patient seems to grasp what you're saying and asks logical, relevant questions. So look for them to kind of give you an idea that they understand what you're talking about. If they understand what you're talking about and they're refusing that, they don't want us to put oxygen on them or something like that, that is their choice. They may want us to take them to the hospital, but they may not want oxygen. They may want us to take them to the hospital, but they don't want you to, put a splint on something or a bandage, who knows what. There's any number of things that they can refuse. They can accept everything or they can accept nothing, or they can accept, hey, I'll let you take my blood sugar and check my blood pressure, but I'm not going to let you take me to the hospital. So all of those things are consent-related issues, and we want to make sure that the patient is capable of making an informed decision. Not a good decision, clearly. That's not up to us to decide what's good and bad for them. That is up to them, but we need to make sure that they are able to make an informed decision about their care and what is going on. All right, so there's different types of consent that we can work under. The first one, of course, is expressed consent. This is when the patient clearly states that they want you to provide care and transportation or transportation. It can be anywhere on that continuum. They may just express consent for some care, but maybe not transportation. But they expressly say, yes, take care of me. Yes, do these things. Yes, give me oxygen. Those kinds of things. For that consent to be valid, it must be informed, meaning that you've explained that treatment, its risks, benefits, alternatives, and what could happen if they refuse. Okay? So you've explained that, what it is that you're doing. Generally speaking, at the EMT level, there's not a whole lot of things that we would consider invasive or procedures that might have risks associated with them. At the paramedic level, oftentimes there's things that we would do that might have some risks associated with them. For instance, we might be going to give them a medication, and we'll let them know, hey, your heart's doing this, and I'm going to give you this medication, but it might make you feel this particular way. It might make your blood pressure go lower or higher, whatever, depending on the medication. We have to make sure that we inform the patient of the risks versus rewards and all that kind of stuff in order for their consent to be valid. But expressed consent is that consent where they say, yes, please do treat me. We ask them, do you want us to can I take your blood pressure? Yes, you sure can. They hold their arm out for you to take their blood pressure, those kinds of things. Implied consent's different, and it can get a little confusing when we get into the this next one or two. Implied consent applies when a patient is unconscious or unable to make a rational, informed decision about their care. In these instances, it's assumed or it's implied that they would want help if they were able to say, yes, help me. So we don't go, oh well, they can't agree, they can't give me expressed consent, so I'm just going to walk away and leave them there because they can't tell me they want help. No, we always act in those instances, we always act under the rule of implied consent. Of course, this should only be used in those serious medical conditions, in those situations where serious times exist, and where there is a threat to life or limb. I mean, so we're not just going to treat somebody under implied consent because they're unable to communicate with us, at a level that we feel like is appropriate. There has to be an overarching danger element to it. It's like, if we don't treat them, they're going to die. So there has to be the threat to life or limb attached to that for implied consent to come into play. If it's like, well, they're not really communicating well, but they don't look like they're in any danger or any threat or anything like that, and we don't know if this may be normal for that person, then implied consent really doesn't float. But if they're completely unconscious, their heart's not beating and they're not breathing, we can begin to do CPR and treating and caring for them under implied consent, because if we don't do anything, they don't have a chance, right? So hopefully you understand that. This principle is referred to as the emergency doctrine. So if you ever hear the term, or if you see it in a question that asks you about the emergency doctrine, that's where we're talking about the implied consent, meaning you can take care of somebody under that emergency doctrine, because not taking care of them puts them at risk of, the loss of life or limb. That's implied consent. When possible, try to get consent from a spouse or a relative before relying on implied consent, but that's not always possible. Sometimes people are out in the public on their own and have family members with them, or family members themselves are in a bad way and they can't necessarily give consent for somebody else. Involuntary consent is a little different. With involuntary consent, this applies to patients who are mentally ill, experiencing a behavioral crisis, or that are developmentally delayed. So they may be telling us no, but because of their condition, we have to kind of set that aside and do what we believe is in the best interest of that patient. Almost every one of these are going to involve somebody well beyond you as the EMT. We're going to be talking with the physician in the emergency room, maybe even law enforcement. So there's going to be some other factors coming into play here. Maybe even family members that have guardianship over that particular person that are saying, no, I want you to do this. I have guardianship. I want you to do this, and take them to the hospital even though the patient is saying no. So they're always a sticky situation. So these are the ones that you want to make sure that you get your supervisors, medical directors, and even law enforcement involved whenever necessary. So ideally, we want to get consent from the patient's guardian or conservator to make sure that we take care of them. If consent cannot be obtained, be aware of local laws such as protective custody statuses that allow law enforcement to take the patient to a medical facility and those kinds of things as well. So these get, like I said, these get a little sticky and they can be a little problematic, but this is the ability for us, this involuntary consent, to treat someone who behaviorally is not making good rational decisions, and they really, really need to be treated. I mean, it's urgent. And these are going to be not necessarily always a life and death, but they're going to be pretty close to that if treatment is delayed, it could, could impact the loss of life or limb. So minors and consent are always creating issues for us. So, think of this: if someone is under 18 years old, but they're 16 and they're able to drive a car and they get in a car accident, they're not hurt and they're telling you, I don't want to go to the hospital, but they're not old enough to sign the form refusing treatment. so that they really fall under the implied consent, because, if there's something wrong, they need to be transported, but they can't refuse. So it gets really, really sticky. So ideally, we have a parent or a guardian that gives consent for that treatment. In some states, minors can give consent for themselves. And of course, an emancipated minor is someone that that's under legal age that the courts have considered an adult due to whatever special circumstances. So an emancipated minor can, give or refuse consent. Many states consider minors emancipated if they're married, in the armed forces, or parents themselves. So that gives you a little bit of wiggle room there that kind of helps. Teachers and school officials can provide consent for treatment of injuries that happen at school or on campus under the principle of loco parentis, which means they are essentially filling the role of the parent, by being the teacher, and the parent sending them to school. So it kind of puts them in that realm. Generally speaking, though, and this is what's odd about it, since a child cannot legally refuse transport to the hospital, you have to have an adult sign off for them, a parent or guardian, or maybe even school teacher. But absent those things, it's almost inevitable that you're going to have to transport them, even when they really don't need to be transported. A little unfair to the parents, because now they maybe get stuck with a bill for something that if they could have said no to, they would have said no. Now, fortunately, we live in a time where we have cell phone access and all those kinds of things, and we're able to reach out to parents much easier than we were in the past. A phone call and a talk with a parent over the phone, the parent can refuse treatment over the phone. If they're not too far away, ideally you let the parent get to the scene and sign and do everything in person. But absent that ability to be able to do that, you can do that over the phone. It's not a perfect situation. Of course, that's going to be dependent upon your protocols, your agency where you work. So always reach out to a supervisor when you're dealing with those types of things. If it's a true emergency and no consent is available, of course, you can treat the minor as implied consent, just as with an adult. So the good news here is, if they're in a bad way, you can just go ahead and treat them under implied consent. Even if the child's refusing and it's clearly they need to be treated, you can treat them under implied consent, because you're acting in the best interest of the child at that point in time. When in doubt, though, with these, always reach out to supervisors, medical direction. Let those with a little more experience kind of help guide you through this decision-making process of what you want to do. Sometimes we deal with some very combative patients, and we need to use forcible restraints, because these people, basically require medical treatment and transport, but they're so combative and they pose a danger to themselves and others that we have to restrain them. Using forcible restraint is legally allowed. However, you should always consult medical control for authorization and have law enforcement present. Both of those things need to happen. Law enforcement may also contact your medical control because they may want to do something, called an emergency order of detention, which they can legally do as well. So this is not something you and your partner are going to go at alone. You're going to make sure that you have medical control, your supervisor, if available, as well as law enforcement present. Restraining a patient without legal authority can lead to big-time civil and criminal penalties. It's actually considered false imprisonment, kidnapping, those kinds of things. You can actually be charged with that if you don't do things correctly. So make sure that you cross all your T's and dot all your I's when it comes to having to restrain a patient. Once those restraints are put in place, you don't remove them during transport unless they are beginning to create a risk to the patient. So if they're causing your patient to deteriorate, then you're going to have to adjust those restraints. but generally speaking, you don't take them off, because sometimes those patients will turn wrong side out when you give them a chance. Consider calling for an ALS backup to provide chemical or pharmacological restraints as needed. So sometimes we're going to call for a paramedic level ambulance that can, give some medications that will restrain that patient. Once the medications are given, that patient is now the responsibility of that paramedic. They're not going to leave them with you now. They will assume responsibility for that paramedic once they begin advanced level care. So patients do have the right to refuse treatment. So adults who are conscious, alert, and have decision-making capacity, they have the right to refuse treatment, even if it could lead to death or serious injury. We hear this happening all the time, but patients have the right to refuse treatment. They can go curl up in the corner and die. It's their right to choose to do that. No matter how much we disagree with that, it is their right to do that, as long as they are conscious, alert, and have that decision-making capacity. These adults can also withdraw from treatment at any time, regardless of the consequences. So we could be treating them and they decide they don't want oxygen anymore and they want to take it off. It is their right to make those choices. We can't force this stuff on them. Calls involving a refusal of treatment often lead to big legal challenges, so you must handle them in a very careful way. And we'll talk about that here a little bit, but we're also going to talk about that a little bit more during the documentation chapter, which is chapter 4 coming up next. Always involve medical control and make sure you document all of your actions, what the patient says, does, all of that, everything that you do, carefully and thoroughly. So assess. The first thing that we want to do when a patient's refusing care is we want to make sure that they have a good decision-making capacity. They're able to make an informed decision. So they can have that decision to accept or refuse treatment, and it should be informed by your assessment of the patient's condition, a clear explanation of the necessary treatment, the possible risks associated with treatment, the availability of some alternative treatment options, and the potential consequences if they decide to refuse treatment. When treatment is refused, evaluate the patient's decision-making capacity by asking and repeating questions to confirm that they understand what you're saying. Asking the patient's answers for coherence and relevance, or assessing, the patient's answers to make sure that they're coherent and relevant. And then, of course, observing the patient's behavior for signs of confusion and impairment. I've asked questions repeatedly so many times, and I intentionally will do it until the patient becomes frustrated with me, and you can tell they're starting to get very frustrated with me because I've asked the same question multiple times just to make sure that they understand it. Once they reach that frustration level, I'll stop asking, but I want to make sure that they understand what I'm saying and what I'm asking. If the patient appears confused or delusional, do not assume that the refusal is an informed decision. So if they're confused and delusional, remember, these are those instances where we're going to start getting other people involved, medical direction, maybe law enforcement, those kinds of things. Having others do a bit of an assessment on this person, family members, others help us with this decision-making process that this patient may or may not have. So we want to make sure that they're able to make a good decision. When we're unsure about the patient's decision-making capacity, it's generally safe and more legally defensible to provide treatment than to withhold it. So always taking the high road is the smarter thing to do, but making sure that you're involving law enforcement when a patient's refusing to go to the hospital with you. That way law enforcement can say, no, that was the right choice. That's exactly what needed to happen, rather than later coming back and you're trying to defend how you kidnapped and falsely imprisoned somebody based on the fact that you thought they should go to the hospital when they could have refused to go, right? So always prioritize your own safety. Don't put yourself in harm's way to provide care. And of course, like I've said, use law enforcement assistance when necessary to ensure that the environment is safe, and also utilizing them as kind of that backup to bounce off whether or not this patient is in any condition to refuse care, or do those kinds of things. Always encourage the patient parent or caregiver to consider and accept treatment if needed, and inform them that they can call EMS again if the condition changes or worsens. Advise them to hit 911 again and call us back if they change their mind. Recommend that maybe they contact their personal physician as soon as they can, or request that the patient, parent, or caregiver sign a refusal form to document the refusal. We should always do that. Ensure a witness is present during the refusal process so they can sign as a witness saying, yep, that person refused. And then, of course, you're going to thoroughly document all the details of the refusal, including the information provided, the patient's capacity, any witnesses, any phone calls that you made to medical control or supervisor, or those kinds of things. You'll document all of those things just to make sure that you cover all your bases. Confidentiality is another big thing that you have to keep in mind. We live in a social media world, and it's really, really easy and really, really tempting to go out there and tell the world about all of the things that we've done, all of the wonderful and great things that we've done. I don't know how many of you actually look at what people post on their social media. I don't so much anymore, but I used to, and I used to look at people's social media accounts that I knew, and I knew well, whether either friends or family members. And the only thing that they ever posted on there was, there was two things. It was either, the greatest and best and the most amazing things, and, a little braggy kind of stuff, or the biggest things that they thought they might get sympathy for. And that's oftentimes what we see people post on social media. Of course, nobody cares about the boring stuff. I get it. That's why we do that. That's why we put those things on there, because they're more interesting and entertaining. Of course, I get the biggest kick out of the ones that are just funny. They're just goofy, funny, silly things, because to me that's more entertaining. But what I'm getting at is we're always wanting to put stuff out there to get attention, to get people to look at our stuff. Hey, look at me. Come look at what I have. Look at what I posted. And the problem lies with when it comes to healthcare is that we sometimes don't think before we post. It is very, very important that you do that. It can be a career-ending and a financially debilitating thing for you to make that wrong choice. So when it comes to confidentiality, keep some things in mind. Remember that the communication between you and your patient is considered confidential. It's the same as, attorney and client privileges, meaning they can't talk about the things that an attorney talks to with their client. It's the exact same thing, exactly the same thing. Confidential information is going to include things like patient history, assessment findings, treatments provided, patient's name, any kind of identifiable information, their address, all of that kind of stuff. All of it's confidential. Essentially, the fact that you know that a call even took place at their house is confidential, completely confidential. The improper release of confidential information without authorization may very well result in liability for a breach of confidentiality. In most states, records may be released only under the following conditions, such as when a patient signs a release form. If there's a legal subpoena issued by the court, that's when it can be released. Or the information is needed to provide for billing insurance companies and those kinds of things. That can be released in those instances as well. We can also release that information when we're transferring care from us to the hospital, those kinds of things. We can give them all that information because it is all related to their care. And those, the people that we're transferring care to are bound by the same confidentiality rules as we are. So here's the continuation of the confidentiality. Like I mentioned, there is certain information that we can and can't release. This Health Insurance Portability and Accountability Act of 1996, and notice that is 1996, not 1896 or 1956 or whatever. This is 1996. This didn't happen all that long ago that this HIPAA law came out. It's a federal law. And what this did was it contained a section on patient privacy that strengthened privacy laws. What had happened, or what was happening, it happened mainly in California with celebrities. What would happen is a celebrity would come in the emergency room doors And before they could get them even checked into a room, the press was showing up at the front door of the hospital asking about this celebrity that had just been brought into the emergency room, because the staff was, picking up the phone and calling, news reporters and saying, hey, it's because these news reporters were giving them kickbacks so that they could be the first on the story. So to stop that, the federal government passed this HIPAA, the Health Insurance Portability and Accountability Act of 1996. So it strengthened privacy laws and made them federal. And it also provided us some guidance on which types of information are protected, the responsibility of the healthcare provider regarding that protection of that information, the penalties associated with breaching that protection. And of course, HIPAA considers all patient information obtained during the course of providing medical treatment to be protected health information. So that says all information obtained. The only thing that is not, that makes it a little bit different, is if you go on a car accident. The fact that a car accident happened at a particular place and time would be public information. But who was involved in that accident, the description of the cars, the types of cars, all of that information associated with the people and all that involved in it is all protected information. So what I caution you to do is every aspect of a medical call that you go on, from the time you're dispatched to the time that you drop that patient off and you finish your paperwork and turn it in, is all protected. Every bit of it, all of it. So if you take that approach, you're going to be okay. Eventually, you'll start to figure out those nuances and those instances of when certain things can be discussed, and speaking in generalities and those kinds of things, so that we're protecting the identities of the patients that we're serving. We do it some in the classroom. You guys are going to go to clinicals. Your instructor is going to talk to you, and he's going to ask you questions about the calls that you went on, but he'll make sure that you don't give out names and you don't give exact ages and that kind of stuff. You speak in more general terms, and there's a little bit of coverage there anyway, because we're using it in a medical training context, but we still need to protect that information. And what you need to realize, any information that you learn that is protected information that you learn about a patient while you're in this EMT program is considered protected information, and you can't share it. So if your instructor shares a story with you and they do happen to give protected patient information, you can't go out and share it with the world. So it's still protected even if it's in the classroom. So it's really important you understand the confidentiality aspect of this. Failure to abide by the provisions of HIPAA can result in a civil and or criminal action against you and or your agency. Usually they come after both of you. The general public is often permitted by law to record identifying and protected patient information and images. So the general public can get away with it. We can't. So bear that in mind. Just because becoming an EMT makes you cross the threshold to maintaining protected health information. And what that means is even when you're off duty, you are held to a higher standard. So just keep that in mind. It's really important to protect the confidentiality of our patients. I just talked about pretty extensively about social media. So unless you're operating in an official spokesperson capacity for your agency, you should avoid logos, uniforms, vehicles, or other markings that associate you with your agency while you're off duty. So you shouldn't post pictures of yourself on social media while in uniform in front of your company truck or things such as that. You should protect those things or guard those things. It's just good practice. It's not a legal thing. It's just good practice. Conduct yourself with the same professionalism that you do while you're on duty, when you're off duty. Respect your patients, their friends and family, bystanders, colleagues, and the organization for which you work, both in person and online. And of course, you should recognize that free speech does not mean everyone has the right to say anything under any circumstance without repercussions. Yes, you do have free speech, but people also have the right to sue you, and free speech won't protect you from being sued. You can still get a lawsuit even though you're using your quote-unquote free speech, your constitutional right, but it can still get you in trouble, so keep that in mind. Another legal bugaboo that we run into, and I've been trying to figure out when I can squeeze bugaboo in there, but another legal conundrum that we oftentimes find ourselves running into are advance directives. You inevitably are going to respond to a call where the patient is dying from some particular illness, and there is a do not resuscitate order that gives permission to withhold resuscitative efforts. Of course, remember that do not resuscitate does not mean do not treat. So as if the patient has a pulse and they're breathing, we're going to treat them. We're going to take care of them. However, if they don't have a pulse and they're not breathing, we're not going to attempt to resuscitate them. That's what a do not resuscitate order is. It means don't try to bring them back from the dead. But that doesn't mean don't treat them at all and push them to death's door. So we still treat people that have do not resuscitate orders. So you're still obligated to provide supportive measures, oxygen, pain relief, comfort, all those kinds of things to a patient who is not in cardiac arrest whenever it's possible to do so. Of course, each ambulance is going to have a protocol to follow in these particular circumstances, and being with a more senior medic will actually help you, kind of understand the nuances of how those things work. Advance directives are a written document specifying medical treatment for a competent patient should he or she become unable to make decisions. These are most commonly used when a patient becomes comatose. They're often referred to as a living will or a health directive, that kind of thing, advance directive. In general, a valid DNR order must meet the following requirements. So, sorry, I kind of skipped ahead. So these advance directives they're usually very wordy and they're multiple pages long. They're written in legal jargon that oftentimes is hard for us to understand completely what it is that we're being asked to do or not to do. Typically, these are what someone would have is if they're like, I don't want to be put on a ventilator, or I don't want to have a feeding tube put in place if I become incapacitated. That's what these advance directives or living wills are. A DNR is different. Basically, that is, if my heart stopped beating and I've stopped breathing, I don't want you to do anything to save me. But if my heart's beating and I'm breathing, I want you to do things to save me. They could have an advance directive along with that, but again, like I said, those things are pretty wordy, and it's us trying to decipher those on the scene when somebody actually needs care is not something that we would do. If somebody says, if their advance directive or living will says, I don't want to be on a ventilator, we would go ahead and do everything that we would normally do when we get to the hospital. The doctor in the hospital would review that living will and make a determination of what to do next, whether to stop breathing for them or, whatever we're going to do or they're going to do. A DNR, on the other hand, in order for it to be valid, it should have a clear statement of the patient's medical problems. There should be a signature of the patient from the patient or their legal guardian, and a signature of one or more physicians or other licensed healthcare providers. DNR orders are actually not forever orders, and they have expiration dates that must be dated. They have to be within 12 months of the original signature date in order for them to be valid. So a DNR has to be renewed every year, and oftentimes family members don't know that. So if you're transporting a patient, which we oftentimes transport lots of patients that have DNRs, if you notice that the DNR is expired, you might mention something to the family and let them know that they have to be renewed every 12 months to be valid. So if it is expired, it is no longer valid. So if they have an expired DNR, it's no longer valid. This is going to make families upset because they know the wishes of their family member, but it is what it is. It's a legal conundrum oftentimes that we find ourselves in. Here's an example of a wallet-sized DNR, and I'll be completely honest with you, I've never ever seen a wallet-sized DNR. In Oklahoma, I do know that DNRs, there is a specific state authorized form for DNRs, so that all DNR forms are the same. So the state determines what those forms look like. I've never seen a wallet one though, and I'm not sure I would go digging in somebody's wallet looking for a DNR if they're in cardiac arrest. That's usually not where I start. So you may encounter physician orders for life support treatment and medical orders for life-sustaining treatment forms when caring for patients with terminal illnesses. You don't see these a lot, but it is possible to come across them. These are medical orders that explicitly describe acceptable interventions for the patient. So it's going to say, do this, don't do that. They must be signed and authorized by a medical provider in order to be valid. If you encounter these documents, and you may have to contact medical control for guidance. Oftentimes they create these documents and they don't really have EMS in mind when they're creating these. So like I said, they get pretty wordy and sometimes difficult to translate. Don't let trying to translate a document hamper or delay your care for somebody. You can always stop care once you've come to the conclusion or you realize what the document says, or it's been translated by somebody that can give you better guidance on that. Some patients may have named surrogates to make decisions for them when they're no longer able to make their own, such as durable powers of attorney for healthcare, and these are also known as healthcare proxies. In these instances, those people that are named as those surrogates that have those powers of attorney are the decision makers. They're going to be the ones that make the ultimate decision about how the care for that person is going to move forward. All right, so sometimes some patients have died or expired before we get there, but while we'll be able to essentially say that they are expired and not transport them, it's ultimately a physician that's going to determine the cause of death. So any unattended death or things such as that are going to require a medical examiner, more than likely in some aspect, or their personal physician to sign off on the death certificate. We as medics can't do that. There are some presumptive signs of death. They're, one of them, not always though. They may be unresponsive to painful stimulus, but that doesn't mean they're dead. But a lack of carotid pulse or heartbeat could be another indication. No breath sounds and no deep tendon or corneal reflexes present. These are presumptive signs of death, meaning we need to dig a little deeper. We might presume that there could be dead if we find these signs, so we need to dig a little deeper. So that's on the presumptive side. So a few more are, of course, the absence of eye movement, low blood pressure, profound cyanosis, and lowered or decreased body temperature might all be indications or presumptive signs of death. So these are all the kinds of things that are going to make us go, hang on, is this person dead? Do we need to start CPR, or are they dead, beyond coming back? Some definitive, and this is what I'm talking about, dead, definitive signs of death are when we have obvious mortal damage, such as decapitation or those kinds of things that nobody could possibly survive, or dependent lividity like we see in this picture. Sometimes it's not quite as pronounced as this, but we can see this, and you can actually see the handprint in the middle of the back. So this is dependent lividity. This is where the blood has pooled. It started to pool in the lowest points in the body, causing that discoloration of the skin. That's an indication that somebody has been deceased for a period of time. That could be 30 minutes to a few hours. This particular person right here has clearly been deceased for an extended amount of time. When we see these definitive signs of death, that's when we're not going to start resuscitative efforts. Now, dependent lividity doesn't always look like this. It looks a little different in its earlier phases when it's beginning to set in. But signs of dependent lividity, that usually doesn't start till 15 or 20 minutes after the heart has stopped beating, and by that time the brain damage is absolutely irreversible. There's no way you're going to reverse that damage. Of course, rigor mortis, or the stiffening, this usually is going to occur 2 to 12 hours after death, and then after about 12 hours it'll go away. So it's a little weird in that respect, but that rigor mortis will set in. Someone's had to have been dead for 2+ hours in order for the body's the chemicals in the body to cause those muscle tissues to stiffen. And then we reach that putrefaction stage, where the body tissues will, depending on the temperature conditions, typically between 40 and 96 hours after death, the body's going to start to decompose. It's going to start to break down, and the tissues are going to start to decay. Agro mortis is the cooling of the body until it matches the ambient room temperature. So the body's going to cool off until it matches the room temperature. That's going to take a little bit of time for that to happen too, but it does happen a little faster than what most people realize. So I mentioned a little bit about medical examiners. So sometimes we have to involve a medical examiner, but that's going to depend on the nature of the scene and the death. In most cases, the medical examiner, or sometimes they're called coroners in some states, must be notified when a patient who is dead on arrival at the hospital, or sometimes called dead on scene. And of course, if there's death without previous medical care, or when a physician is unable to state the cause of death, these are typically, sometimes those, it may be a completely, normal death, but for whatever reason that person was not under medical care. Well, you see it sometimes with some, elderly people that, just have chosen not to see a doctor on a regular basis. So they don't have a physician that's regularly taking care of them. That's typically when we'll see medical examiner cases come in. Of course, if there's a suicide or a violent death, those are medical examiner cases. Oftentimes we don't know that the medical examiner has been called in on those, because law enforcement typically takes care of that. And of course, poisonings or unknown suspected deaths, or any kind of suspicious death, is going to be a medical examiner case. It's not unusual for the medical examiner to want to talk to one of the medics that are on scene to get an idea of what that scene looks like and whether or not they need to come out and investigate it. So don't be surprised if the medical examiner needs to speak with you while you're on the scene, because you're their eyes, and you're going to help them see the scene better and make a decision on whether or not it needs to be a state's medical examiner's case. So anytime there's a death from accidents or the suspected of a criminal act, a medical examiner is going to be involved. Infant and child deaths, almost every one of those without question, or just a oddly timed death of an adult, somebody in their 20s or 30s, and it's like they just killed over dead. We need to figure out why this happened, just to make sure there's not any kind of criminal activity involved, and to just, quite honestly, just to know what happened. You should make every attempt to limit disturbing the scene involving a death. If emergency medical care has been initiated, make sure you keep good notes of what you did and what you found, those kinds of things. Very much like managing any other crime scene that you may be taking care of somebody at. Special situations that we run into, sometimes we deal with organ donors. Organ donors have basically expressed their wish to donate their organs. Consent is typically evidenced by information on a donor card or even on a driver's license. In Oklahoma, it's a little heart in the bottom right-hand corner that indicates that they're an organ donor. So you want to make sure that you treat potential organ donors the same way that you would any other patient. I'll be honest with you, in my career, we rarely ever looked at the fact that someone was an organ donor. We would transport them to the hospital. That's typically when we found out that they were an organ donor, and that there may be some viability there. There's a lot of variables and a lot of things that go into that, but we want to keep that in mind. once we've pumped their bodies full of different types of drugs, the viability of them being an organ donor begins to plummet rather quickly. But realize, regardless of that, your priority is to save the patient's life. Clear and simple. Who cares about organ donation? The organs in this patient are the most important ones, and we want to keep them all attached to our patient. We want them to be able to keep their organs and go home and spend the rest of their life with their family. But remember, though, that those organs need oxygen. So if we're doing a good job caring for our patient, we're going to be able to take care of the organs that may be viable, that may wind up being donated to somebody else. Here's an organ donor sample card. These are fairly common, and sometimes you'll find them in people's wallets. Again, it's not somewhere that we typically start out looking for. It's oftentimes something that we find out later on at the hospital. Sometimes we're well and gone back to the station before the hospital even knows it. So we also need to take a peek, and during your patient assessment, when you're learning patient assessment, you're going to learn to keep an eye out for bracelets, necklaces, keychains, or cards indicating do not resuscitate orders, allergies, or other serious medical conditions that might be helpful in assessing and treating the patient. However, just because somebody has a DNR bracelet, necklace, or keychain doesn't mean that they have a valid DNR. You're always going to have to look for that valid DNR and make sure that it's valid. So those are just not typical things that we see, but we do see a lot of them with allergies and serious medical conditions like diabetes and those kinds of things. Some patients wear medical bracelets with USB flash drives, and they often have stored on those flash drives a PDF file that you can read on most computers. And what some of them will have on them is their medical history, their medications, and all those kinds of things that their complete medical record, essentially, so you would have access to those kinds of things. And this is just an example of a medical alert bracelet. They make necklaces like that, but typically they're a pretty good indicator that there's something going on. On the back side of that, it'll tell you what it is. Now, it doesn't necessarily mean it's going to be an absolute about what the issue is with them. However, it might be a good starting point, a good place to start. So, scope of practice is something we talked about a little bit earlier. In I think chapter 1, we kind of mentioned a little bit about scope of practice, but just to bring that back up, because we are talking about legal aspects, it's really important that you operate within your scope, within your defined set of skills and abilities that you have. So the scope of practice for EMT actually outlines the care you are able to provide. Now, if you're a big time nerd like me, you would want to know what that scope of practice looks like. You can do that. You can go out at any time. Go to www.ems.gov, and look for the EMT scope of practice. You have to poke around on there. There's a couple. I could go right to it, but I'm not sure I could explain where it's at. But you can find it on that website, or you can do a Google search, EMS scope or EMT scope of practice. Just make sure you're looking at the most current one that I think came out, oh my goodness, 2021 maybe, somewhere around there. Just make sure you're looking at the most current one. But it'll outline what the scope of practice is for all EMS providers. However, that is the federal document. A lot of times state laws, almost every state's going to define exactly what that scope of practice is, and there'll be some state document for that. So you can go out and look at the federal document that most states just adopted wholeheartedly. Others made a few modifications to them. Oklahoma did make a few modifications, but they didn't take anything away. They only added to a couple of things at the EMT level. I can't remember exactly what they are, but EMR and EMT had a couple of things added. The medical director can further define the scope of practice by developing protocols or standing orders, and they can even request from the state that their medics be able to do something that is beyond the normal scope of practice, and the state will go research that and make a determination. Of course, anytime that happens, there's going to be some training that's going to be required in order to be able to do that. So procedures that happen outside of the normal scope of practice can be considered, procedures, got distracted. Carrying out procedures outside of the normal scope of practice would be considered negligent and criminally offensive. So literally, there would be some significant legal ramifications if you act outside of your approved scope of practice that's approved by your medical director. Now, there are instances that there's some things that are loosely within your scope of practice that you can call, say, the emergency room physician or your medical director, and they can give you authorization to do that. However, you can't call them up and say, hey, look, I want to do an emergency field cricothyrotomy on this patient, and as an EMT, you've never been trained to do that. So even if they gave you authorization to do that, that is well outside of your scope of practice, and you would be opening yourself up to criminal liability or criminal negligence. So you got to be careful about that. There are standards of care that we need to follow, and of course, the standards of care basically outline the manner in which you must act or behave, and that umbrella is what all of us fit under. It is defined as how a person with similar training would act under a similar circumstance. So basically, we want to make sure that we're all providing the same care. It's a kind of a cohesive thing, that we're doing the same thing. So standards of care are established in many different ways. Some of them are imposed by a local custom, such as how a reasonably prudent person with similar training or experience would act under a similar circumstance with similar equipment and the same similar place. Some standards are imposed by law, and these standards of emergency care may be imposed by statutes, ordinances, administrative regulation, or case law. So it's important that you're familiar with the particular legal standards of your state. There are some professional and institutional standards that exist as well. Recommendations published by organizations and societies involved in emergency medical care. For instance, the American Heart Association standards for BLS and CPR, and there's specific rules and procedures outlined by your agency. There may be some standards also imposed by textbooks. Almost all textbooks follow the same education standards established by the National Highway Traffic Safety Administration. So those standards will probably all be the same for everybody. Local protocols or state standards may differ a bit, but it's always important for you to fall back on your local protocols. What you need to realize is this EMT class is going to teach you in EMT generalities. Basically, we're going to teach you according to the scope of practice of what an EMT can legally do, and then it's going to be up to where you go to work that will give you those outlines of, they'll give you the parameters of what you need to work within. They may take some things out of your scope of practice, and they may add a thing or two in your scope of practice, depending on what they've gotten approval from by the state. So always fall back on your local protocols when it comes to how to treat and care for patients and how to do particular things. Many organizations also have standard operating procedures or SOPs of how and what you do in a given situation. So there is a Medical Practice Act. In some states, the EMT is exempt from license requirements of the Medical Practices Act. Oklahoma is not one of those. And then there's, of course, certification and licensure that we talked about in the first chapter. It's also known as credentialing. And this credentialing is an established process to determine the qualifications necessary to be allowed to practice a particular profession or function as an organization. So EMTs may be licensed or certified depending on the state that they're working in. It's really just semantics. It means essentially the same thing. In Oklahoma, it's considered licensure, but in order to get licensed, you have to be certified at a national level. So So here's how it works. You finish this class. We're going to teach you all that we can. And then when we're done, and you've done everything that you need to do, and you've done it to the level that you need to do it, we will give you the stamp of approval to go take the National Registry of EMTs exam at the EMT level. So the NREMT EMT exam, I know it's a lot of EMTs in there, but you'll be authorized to go take the Emergency Medical Technician exam from the NREMT. Once you pass passing that exam says you have met the minimum standards required to work effectively as an EMT. Once you have that, then you can take that certification and fill out an application for licensure, state licensure as an EMT in the state of Oklahoma. And you put your certification with that and your application and a few bucks, and you send that to the state and they process it and send it back, and congratulations, you're licensed to practice or licensed to work as an EMT in the state of Oklahoma. That's only in the state of Oklahoma. Generally speaking, you would have to do that in every state, but there is some legislation, I think it may have passed, that allows your license to be valid in neighboring states. Without getting too deep into that, there is some wiggle room for working out of state. Now, if you move to another state, you would have to take your National Registry certification and apply for licensure in that state. So that's where those standards come from. Now, let's talk a little bit about a duty to act. So what is a duty to act? Basically, that's an individual's responsibility to provide care. Once your ambulance responds to a call or treatment has begun, you have a legal duty to act. And honestly, it actually starts before you respond to that call. When that call comes in and you're working as an EMT and you're the next ambulance up for the call, and that call comes in, you have a duty to act. You have a responsibility to respond to that call. And especially once you've started to respond and you've initiated treatment, you have a duty to act. Legally, you're bound to act. In most cases, if you are off duty or come upon a crash, when you're not at work, you're not legally obligated to stop or assist patients. Be sure to know your local laws and policies pertaining to your duty to act, especially outside of your normal work days. Generally speaking, in Oklahoma, you do not have a duty to act when you're off duty to assist others or stop at car accidents or provide medical treatment, in any way. Remember, you would only be able to do those things that fall under Good Samaritan anyway. You wouldn't be able to do advanced procedures because you're not working under a physician. So, however, it would be, not really cool to have, big old EMT tag on the front of your car and little stickers all over your car about you being an EMT and an EMT tag and all that cool stuff on your car, and then just drive right past people that need help. That would look really, really bad. So think about that before you put all that stuff on your car, how bad that's going to look for you and the profession, to just drive on by an accident of people in need when you're advertising that you're an EMT. I'm just saying, make of it what you will. Now, negligence is when there is a failure to provide the same care that a person with similar training would provide in the same or similar situation. So that's the definition of negligence. So another medic, what would they do in the same or similar situation? All four of the following factors must be present for the legal doctrine of negligence to apply, and for a plaintiff, the person suing you, to prevail in a lawsuit against an EMS service provider. So how do you get sued? How do you find yourself in a situation where you're negligent, where you failed to do, or you're being accused of failing to do what you were legally supposed to do, that duty to act? So here you go. Here's all four of these elements have to be in place in order for it to be determined that you were negligent. So the first one is, was there an obligation to provide care? Was there a duty to act? Were you legally obligated to do something to help? Okay, that's the first one. Was there a legal obligation? Did you breach that duty? Did the EMT not act within the expected and reasonable standard of care? Did you breach the duty that you had to act? Based on that breach of duty, were there damages? Is there physical, psychological harm done in some noticeable way that happened? And is there a cause and effect relationship between the breach of duty and the damages that the patient suffered? So all four of those elements have to be in place. It is a bit of a steep climb. However, it can be met pretty easily if you do something stupid. So remember, the four elements of negligence. Was there a duty to act? Did you breach that duty to act? Were there damages because of that duty to act? And can the damages be directly related to your lack of duty to act? Did what you did result in damage or harm to the patient? So those are the four elements of negligence that have to be proven in court if you're taken to court because somebody says you didn't do your job. I don't know if I can say this word. It's like re ipsa loquitur. I don't know if that's even close. As an EMT can be held liable under this theory if it can be shown that an injury occurred, that the cause of the injury was in the control of the EMT, and that such injuries generally do not occur unless there is negligence. So we can fall under that too. And then of course there's negligence per se, is a theory that can be used when the conduct of a person being sued is alleged to have occurred in clear violation of a statute. For example, an EMT performs an ALS skill that resulted in injury to the patient. So that would be a neglect per se. Well, they were trying to do the best good. They were trying to do the right thing. And it may not fit all the elements of negligence. What they did do is they performed medicine without a license that resulted in a negligence per se case because they did not have the proper training and knowledge to perform that ALS skill. So hopefully that makes sense. So we can have negligence and negligence per se, but they're a little different. Now torts are a little different. These are civil cases. This is where the patient sues you. Negligence cases, can be civil lawsuits as well. But anytime you're looking at jail time, that's a criminal matter. And anytime you're looking at a tort case where a person is suing you, that's a civil case. So you have criminal and civil. Sometimes you can wind up with both of them simultaneously. So a tort is a civil wrongdoing. It's not within the jurisdiction of criminal courts, so it's not a criminal action. And of course, examples of this are going to include defamation of character or invasion of privacy. Maybe you went out there and posted something online, or maybe you were convicted in criminal court of negligence, and that now you're being sued by the family or the patient because of that negligence for damages. So anything's possible when it comes to that. So do these things happen all the time? I think it's important to kind of throw this in there. No, it doesn't. Most employers have pretty good liability insurance as well, but it's a pretty rare occurrence to get sued. You have to do a pretty dumb thing in order to get sued, and that's why I've tried to stress to you, stay within the confines of your protocols and your scope of practice, and you're going to be okay. You're not going to open yourself up to all those liabilities. Another big area that we could wind up, showing some liability in is the area of abandonment. And this can happen easier than you think. So abandonment is basically the unilateral, meaning we decided to terminate care of a patient without the patient's consent and without making any provisions for care to be continued by some other medical professional who is competent to provide care to the patient. So basically we just decided, I'm not going to treat you anymore. I'm done with you. I'm going to move on. And the patient, that's not what the patient wanted, and we didn't make provisions to make sure that the patient received the care that they need. So remember, once care is started, you have assumed a duty that must not stop until an equally competent medical provider assumes responsibility. It has to be minimally equal. Okay, so another EMT. You can pass them off to an advanced EMT, a paramedic, a nurse, a doctor. You can pass them on off. That's fine, but you can't pass them down to an EMR. There's very few exceptions to that, and they usually have to do with mass casualty type of incidents. But generally in those incidents, you're probably not going to be the first one to start care anyway. So that there's some little nuances that might apply in those situations as well. So we'll talk about those later when we talk about mass casualties. So abandonment can take place at the scene or in the emergency department when you're dropping off a patient. You have to make sure that you're handing that patient literally off to somebody and not just dumping them in the hallway. Obtain a signature on your patient care record from the person accepting the transfer of care of that patient to the hospital. You'll notice every one of those patient care reports have a signature spot for whoever's taking, assuming the responsibility of care of that patient from you. Always make sure that you're cautious about abandonment and you're not abandoning your patients. Now, simply having to step away to check on another patient for a moment is not necessarily abandonment. Say you're at the scene of a car accident and there's multiple people injured. You start the care on one patient, your partner calls you over to take care of another patient, and you trade places and your partner's an EMR. They're kind of holding down the fort with the first patient while you maybe do something quickly with the second patient, and then you move back and forth like that, and they're in close proximity. That's not that you're abandoning them. That's that you're trying to do the most for the most people and trying to take care of everybody. That's not abandonment. If you got in your truck and left, if you got in your ambulance and left, that would be a clear case of abandonment. So moving from one patient to another and staying right there in the proximity of caring for everybody is not abandonment. Assault, battery, and kidnapping, we talked a bit about this. This can happen really easily if you're not careful. It's basically unlawfully placing a person in fear or immediate bodily harm. This includes threatening to restrain a patient who doesn't want to be restrained, or unlawfully touching a person by trying to restrain them. So it includes providing emergency care without consent. So assault and battery you can be charged with this. It's a criminal activity. They're criminal things that you can be charged with if you're overzealous. That's why it's very important to make sure that you get permission from your patients and you listen to them and follow what their desires are. Kidnapping, or of course, is seizing or confining or abducting or carrying somebody away by force. Yes, strapping somebody to the cot of the ambulance and driving away with them to the hospital is kidnapping. 100% it is kidnapping. If they're transported against their will, they have been kidnapped. And they could even argue that they've been falsely imprisoned. So that could come along the way as well, because we've confined that person to a particular area, and that would be considered imprisoned. Serious legal problems are going to arise in situations when a patient is not given consent or they rescind that consent for treatment or transport. So be cautious about that. Don't just load them up and take them. It's like, well, you're going anyway. We got bills to pay. We need your insurance money. Don't do that, or you're going to die, so we're taking you. We don't think you're smart enough to make that choice. It doesn't work like that. Remember, you always want to err on the side of caution and make sure you've got all the bases covered. Yes, there may be other calls waiting and that kind of thing, but don't abandon that patient, because it'd be really easy. They say they don't want to go and you just abandon them and leave. Don't do that. Make sure you get all the paperwork done. Make sure you do your full assessment to make sure that they are consenting. They're able to consent or they're able to refuse, that kind of thing, before you leave them behind. And don't just take them. Don't go, okay, we ain't got time for this. I'm going to throw them in the truck and we're going to go, because that's assault, battery, and kidnapping. Of course, if we communicate false information that damages a person's reputation, that's going to be defamation. It would be considered liable if it's written, or slander if it's spoken. Once again, this is why I say stay away from social media as a medic. Don't put your calls and stuff out there, because You'll put something out there that you don't think can be linked to somebody. You think, oh, there's not enough information, nobody will be able to figure it out, and they do, and you've made some derogatory comment about this person or people or whatever, and that comes back to haunt you, and it is defamation. It is clear-cut defamation. So just stay away from it. Don't put yourself in that position. All statements, of course, realize this too, not just social media, but all of the statements that you put on your run report can fall into this category as well. That's why I always tell people, make sure that what you put in your run report is objective information only. It is things that are objective. They're things that you've seen, you assessed, you found, you touched, those kinds of things. It's not subjective. It's not your thoughts. It's not what you think. It's not your opinion or anything like that, because those are the kind of things that will get you in trouble. Now you can put quotes from your patient in there about things that they've said, and that, because that's a very objective thing to do. You can objectively say the patient said this and put it in quotes, but you can't put in there, well, I think the patient's crazy, because that could fall under defamation, and it would be liable. And if it's clearly written and then you sign your little name on the bottom of it, guess what? You're going to have a hard time defending that. Good Samaritan laws are helpful to us, but they don't cover everything. Good Samaritan laws are a good thing. And this is probably what keeps us out of the bulk of the liability or the risk of liability that we run into, in our careers. So the Good Samaritan laws are based on the common law principle that when you reasonably help another person, you should not be held liable for errors or omissions that are made while giving care. So the Good Samaritan law, it ties back to the biblical Good Samaritan that stopped along the trail to help somebody else that, basically was of a different nationality, that no one would expect that Samaritan to have stopped and helped someone of this particular nationality. Basically, you're trying to do a good thing and you shouldn't be punished for it. We shouldn't discourage people from being willing to take the time to help somebody else, as long as their intentions are well-meaning. So in order for us as EMTs to be protected by provisions of the Good Samaritan law, several conditions must generally be met, and they're not hard to meet. So the big thing is that we acted in good faith in rendering care. We legitimately was just trying to be helpful. That's all we were doing. We were just trying to help. We had no ulterior motives or anything like that. We just tried to help. We also have to be able to render care without the expectation of compensation. So we're doing it not because we think we're going to get some big reward in the end or anything like that. We're doing it just completely out of the kindness of our own heart, expecting nothing in return. And that we also acted within the scope of our training. Now, I would say, and I always tell our advanced EMTs and paramedics, not to do any invasive procedures, not to do things like starting IVs or giving medications or doing those kinds of things. Now, you as an EMT, if you're assisting somebody that's having trouble breathing while you're off duty, maybe you're at a restaurant, someone's having trouble breathing and they tell you I have an inhaler, and you help them use their inhaler, that's fine because they have a prescription for that. A doctor said they can have that. However, me as a paramedic, I can't give somebody my inhaler, even though I could do it on the job under a protocol, not my inhaler, but you get what I'm saying. I couldn't give them medicine that a doctor hasn't prescribed for them. So I won't do any procedures that are considered advanced procedures, like anything that's going to penetrate the skin, anything that's going to go into the body, like medications or anything like that. And that's what I would caution you to do as well, in order to keep under that Good Samaritan realm and reduce the likelihood of being sued. Of course, and lastly, that you did not act in a grossly negligent manner. You didn't, you knew that what you needed to do and you did it right. You were trained right and you did it correctly. You wasn't like doing field experiments of like, I've never cut a hole in somebody's neck before. I think I'm going to try that and see if it helps this guy. Yeah, but they broke their leg. Yeah, but I just feel like that, that might help, cutting a hole in their neck and, putting a tube in there to breathe for them. So, as long as you're not doing something crazy like that, you're going to fall under the Good Samaritan protection. And this does protect us while we are on duty and off duty. It's interesting how, to a small degree, it protects us on duty, but to a much larger degree, it protects us off duty. So should encourage you to not be leery about stopping and helping others that are in need. Of course, when we talk about gross negligence, we're talking about conduct that constitutes a willful or reckless disregard for a duty or standard of care. If you're not trained to do it, you by no stretch of the imagination should ever even consider doing it. If you haven't been expressly and explicitly trained to do a particular thing, do not do it on people or animals or anything else. Immunity statutes do apply to EMS systems that are not considered governmental agencies. So sovereign immunity provides limitations on liability, and it is not complete. So there is sovereign immunity is kind of a little weird kind of a thing where like the state of Oklahoma can't be just randomly sued by somebody because the stop sign on a state highway was faded or something like that. Who knows what? They have sovereign immunity. They're immune for those types of things. Ironically enough, the state could claim sovereign immunity even if a highway patrolman wrecks into somebody else's car, totals out their car, driving their patrol car, crashes into a citizen's car, totals it out, destroys the car. The state could claim sovereign immunity, and the person's car that got destroyed would be kind of just out. They'd be out of luck. Hopefully they've got full coverage. I've heard that's happened in the past, but I don't think it happens now. That's just not, it's not a wise thing to do for the state. It really kind of gives the state a black eye. So generally now they do, but they could literally say, well, we have sovereign immunity. There's nothing you can do about it. You can't sue us to make us pay for that. So what I'm getting at is to a small degree, EMS has some sovereign immunity. From some of those things, we do have some protections, but it's not absolute. So there is some room. There's some vulnerabilities in there that could be problematic. Usually those are governmental agencies too that have that immunity. You should make sure you compile a complete and accurate record of all incidents involving sick and injured patients. Such a record is an important safeguard against legal implications because it's going to be your documentation of what actually happened on that call. And if anything's called into question, you can pull out your documentation of that. The court's perception of records and reports, if an action or procedure was not recorded on the written report, it wasn't done. So keep that in mind. If it's not on there, if you didn't document it, you didn't do it. If you didn't document that someone's lungs were clear and they didn't have wheezes, then there's no assumption that that's the case. You have to actually document those things on there. So even if everything is perfectly normal, you need to document everything is perfectly normal. If something is abnormal, you need to document that one or those things that are abnormal, because if you omit it from your reporting, from your records, the courts are just going to say, well, you didn't report it, it didn't happen. Incomplete or untidy reports are evidence of incomplete or inexpert emergency medical care. So if your reports are sloppy with misspelled words and those kinds of things, it's not going to reflect well on you as an expert witness. So bear those things in mind. Fortunately, we live in a world where everything's done electronically now, and spell check is our friend. So hopefully we're not running into a lot of issues with misspelled words. I know that's been a huge savior of mine because I am a terrible speller, and I've always struggled with that. So having the autocorrect features of documentation is helpful. Just make sure, because like your iPhone, the autocorrect feature sometimes will autocorrect things that they shouldn't correct to. Just a quick story. I don't normally tell stories in these, but I'm going to give you one. I was sending an email to a hospital colleague, someone at one of the local hospitals, and at the end of the letter, I was apologizing for some error that we had made with one of the students. And at the end of the letter, I said, please forgive us of any inconvenience this may have caused. and my inconvenience was underlined in red, so I knew it was misspelled. So I just right-clicked, picked the first option on there, done, and was about ready to send it. And I thought, I'm going to proofread this, and I read it, and spell check corrected it to, please excuse any incontinence this may have caused. And if incontinence is one of those medical terminology words that, if you know what it means, it would have been very embarrassing to have sent that, because I seriously doubt I caused anybody to wet their pants over the error that we had made. But so watch, don't wholeheartedly trust spell check or autocorrect. You know how iPhones will correct things to not at all what you meant. So make sure that you proof your documentation before you submit it, because you could look foolish trying to explain that in a courtroom. Of course, there is a National EMS Information System, NEMSIS. I think most states report into this. Basically, it's reporting all the run data and information about all the patients that we run on. Now, don't know that it has patients' names and those kinds of things, but it does have ages and genders and all that kind of stuff in that. This is the ability for the federal government to collect, store, and share standardized EMS data throughout the United States. So we can collect statistical information and lots of EMS data. Oklahoma has a system, it's called OCHEMSYS, that it collects the Oklahoma batch of information, and then they send that to NEMSIS. I'm sure other states do similar things. So all of those electronic patient care reports that you fill out on, on a computer or a tablet or whatever, as an EMT, all of that data is collected into a state database, and then it's sent to a national database. So that information gets sent out there. I don't know exactly what information from that gets sent. I don't know if your patient narratives and all that gets sent, but it does share information on a national level. So there are some mandatory reporting requirements, some incidents that you may come upon that you are legally required to report to authorities. That way they can be further investigated. Of course, most states have a reporting obligation for healthcare providers and emergency responders, which includes you as the EMT. There are things like child abuse, abuse of an elder person, abuse of an at-risk adult such as a special needs or handicap or debilitated adult, injury during the commission of a felony, drug-related injuries, or even childbirth. You wouldn't think all of those things that I mentioned, and then childbirth at the end, but all of those things have to be reported. There are reportable things that need to be reported. So if there's a birth at home and they refuse to go to the hospital, which they most certainly can, that still has to be reported. You would report it probably to your medical director of the hospital, and then they would probably follow through on that and take care of that in the route that it would need to go. But it's important that we report those things. Some states also require reporting of suicides, dog bites. Oklahoma too does communicable diseases. Assaults and domestic violence, of course, are going to be all reportable offenses. So hopefully on suicide, assault, domestic violence, dog bites, those kinds of things, you're already going to have law enforcement presence at the scene of your incident, so that the reporting of that will be relatively simple. And yes, having law enforcement there is essentially that it's reported, but I would make sure that if it's child, elder, or special needs, abuse, those kinds of things, that I would have that conversation with them and say, hey, are you gonna make sure this is reported to the proper state agency, because it does go to the state agency, that reporting does. So also there's sexual assaults and rapes, exposure to infectious diseases, which we kind of talked about. If we have to transport a patient in restraints, crime scenes, and of course deceased. These are going to get reported in different ways to different places and not the same agency. So it's going to be a different agency, different state agency, different local or municipal agency that's going to handle each one of these things based on the particular thing that it is. So it's going to be different for each one. Now, let's talk a bit about ethics and ethical responsibility. This is always one of those things that people have a really tough time understanding. So, in addition to legal duties, EMTs have certain ethical responsibilities as healthcare providers. And of course, ethics is the philosophy of right and wrong, moral duties, and the ideal professional behaviors. Morality is the code of conduct affecting character, conduct, and consequences. And of course, then we have this little thing of bioethics in here that specifically addresses ethical issues that arise in the practice of healthcare. So ethics is sometimes a little bit tougher to nail down, but typically it's tied back to the moral. It's the right thing to do. What would another medic in a similar situation do? It's kind of the ethics of the job. You could spend a whole 8 hours in an ethical class learning about ethics. So EMTs are going to encounter all kinds of ethical dilemmas that will require you to evaluate and apply ethical standards. Sometimes you'll apply your own standards, or at least you need to make sure you're familiar with your own standards. And this is oftentimes where we get in trouble, where we think we should apply our own personal ethical standards to every patient, or we should expect every patient, to abide by what we believe is the right thing to do. For instance, you have a situation where a patient is critically injured in an automobile accident, but they are of a particular faith or belief that they don't receive blood products or have surgeries, and they urgently need emergency surgery to save their life. But the patient, the family members, and all of their friends are refusing blood products or surgery because it is against their religious beliefs. It's really easy to try to apply your own standards to this and make it more difficult. But what you need to do is apply the ethical standards of the profession, and that is patients of sound mind have the right to refuse care. And maybe that's not the best ethical example, but it is an example of an ethical dilemma. So be cautious about applying your own ethics and try to understand the ethics of the profession, what other medics in the same situation, regardless of their own personal beliefs, would do for a patient in a given situation. So, and then there's also, we should allow for rules, laws, and policies to guide that decision making as well. So it's not just ethical. Typically, ethical instances come into play when it doesn't fit a rule, law, or policy. Now we've got an ethical problem. How do we handle this? Because there's no clear-cut rule, law, or policy that this pertains to. And now we've got to try to figure our way through this. And that's the best way to do it, is to go, how would another medic in the same situation handle this call? So, if you wind up in court, it happens. Oftentimes we can wind up in there as a witness. That's the most of the time when I've ever wound up in court. I've never been in court as a defendant, so that should be good news to everybody. But I made it my goal and mission in life is to not do stupid stuff and stay within the confines of what it is that I'm supposed to do, follow my protocols, and do those kinds of things. And that's kept me out of court for everything except for a witness to a criminal act or a crime or something like that. The case could either be criminal or civil. All of mine have been criminal cases, not civil, but I've known a lot of my colleagues and friends that have been in on the civil side of things as witnesses, not as defendants, fortunately. When you're called to testify, make sure that you let your boss know. And of course, you're going to have to try your best. It's going to be difficult. You have to remain neutral in your testimony and review the run report before your appearance in court. Oftentimes, you're going to sit down with whoever is calling you as a witness, whether it's the defense attorney or the prosecuting attorney. They're going to call you in. They're going to ask you very specific questions. And they're going to want, because they're wanting to know how you're going to answer those. They're not going to coach you on what to say or anything like that, but they might inform you of what to expect. When you go in the courtroom, there's going to be this, the jury's going to be sitting here, you're going to have this, it's going to be quiet, all eyes are going to be on you, you're going to feel uncomfortable, you're going to feel nervous, but don't worry, I'll be right there. You just look at me and I'll and answer my questions. They're going to do things like that are going to really help you get through the process, but they will not tell you what you should say or what you should testify to. So they just won't do that. I mean, it's illegal for them to do that. It's a crime. So they're not going to do that. As a defendant, an attorney is required to, the attorney is generally supplied by your service in a civil suit. So your company's going to provide you with an attorney. And of course, defenses, how you may defend yourself could, you could use the statute of limitations, meaning the time which in the case must be commenced maybe has expired. There could be a governmental immunity, meaning that the municipalities or other government entities may be immune to that particular lawsuit. And there could be some contributory negligence, which is oftentimes what we see. It's a legal defense that may be raised when the defendant feels that the conduct of the plaintiff somehow contributed to injuries or damages sustained by the plaintiff. So somebody's suing you for something that you supposedly did or didn't do after they were involved in a car accident. However, it was determined that they were at fault. They were the one that caused the car accident because they were intoxicated and they weren't wearing their seatbelt. So that particular person would have contributory negligence because some of the things that they did contributed clearly to the accident they were in. And had they not made those choices, the accident wouldn't have happened. And we wouldn't have done whatever we did that made them think that we were negligent. So there's some elements to that kind of come into play. Discovery is an opportunity for both sides to obtain more information to reach a better understanding of the case. Discovery is going to include interrogatories or written requests and questions of information. You may be given a long list of questions to answer. And then, of course, depositions, which are oral requests or questions. Usually you have both sides setting in on those. Each side is asking you questions. And all of those are legal. You need to realize if your written requests and questions and even oral requests and questions are all legal and admissible in court, so they can be brought into court. Those things can be utilized in the courtroom. Most cases are settled following the discovery phase during a settlement phase, and they typically don't go to trial. For those that do, there are several types of damages that could be awarded. There's compensatory damages, or they're intended to compensate the plaintiff for injuries he or she was sustained. And then there's punitive, that are intended to deter the defendant from repeating the behavior and are reserved for cases where the defendant has acted intentionally or with a reckless disregard for the safety of the public. These damages are not commonly awarded in negligence cases. They're usually just given the compensatory damages, so they're out what they're lost. All right, so in most cases, if a judgment is rendered against you, your service or the insurance carrier is going to pay that judgment. That's typically how that works. And any EMT charged with a criminal offense should immediately secure the services of a highly experienced criminal attorney. Don't leave that up to your service to provide for you. It's not like an episode of Law and Order. People don't get called into the interrogation room and automatically spill their guts. If you find yourself on the wrong side of things, you should not answer anybody's questions, and you should seek the advice of an experienced criminal attorney. They're going to tell you what you should and shouldn't talk about, who you should and shouldn't talk to, those kinds of things, because they're the only ones that are going to look out for your best interest, because you're paying them to look out for your best interest. So keep that in mind. If you're being asked questions by police officers, they're trying to assess whether or not who's going to jail and for how long. They're trying to prosecute you. So All right. So, chapter 3. Oh, I went a little bit over an hour and a half. Sorry about that. I was trying to keep it to an hour and a half, but I knew there's a lot of information, a lot of things to talk about in that particular chapter. So, that's the end of chapter 3. Study up for that test that'll be coming up on it. See you guys back in chapter 4.